Good afternoon. Today is March 19, 2025, and this is a meeting of the Cities and Counties Subcommittee. Welcome, members and guests. Committee will be in order. Will the clerk open the voting board so the members may register their presence? Every member, please register their presence. Give Chairman Crawford just a moment to sign in. And Representative Dixie. Madam Clerk, take the roll.
Mr. Chairman, you have 7 members present. You have a quorum.
Thank you very much, Madam Clerk. Any members need to recognize anyone in any personal orders? I have one quick one. Blount County Assessors here, Todd Orr. Hamilton County Assessor is also with us, Marty Haynes. If you'll stand and introduce yourself, sir. Thank you, sir. Please. Thank you very much. Representative Butler, you're recognized. She's right.
Thank you, Mr. Chairman. I do want to point out that Kara Boone, the Overton County Assessor, is the Assessor of the Year from House District 41.
Representative Dixie, yes. Representative Dixie, you're recognized, sir.
I'd like to recognize our Davidson County trustee, Erica Gilmore.
Yes, thank you.
And its friend, Eugene Hampton. Thank you.
Any other personal orders? Seeing none, we're going to begin the final calendar today. First bill on our calendar is House Bill 808 by Chairman Grills. We have a motion. The second, Chairman Grills, you're recognized on the bill.
Thank you, Mr. Chairman. And the reason I brought this bill was because my county there in Northwest Tennessee, Lake County, had been struggling every year with unfunded mandates from the state. Every year we give the state employees a raise, and by virtue, the elected office holders get a raise as well. And those office holders getting those raises forces that legislative body to raise taxes every year just to meet the unfunded mandates from the state. And I brought this bill to bring attention to it. And then no county official wants, no mayor wants unfunded mandates. No county official wants unfunded mandates unless it benefits them. And that's what this bill is trying to curtail. But I understand we brought a lot of attention to that. And with that, Mr. Chairman, I'd like to take this bill off notice.
Without objection, House Bill 808 is off notice. Our next bill on the calendar is House Bill 832 by Speaker Marsh. Is Speaker Marsh available?
Move to roll 5 spaces.
Let's see. We're going to roll this bill 5 spaces. Next bill on the calendar is House Bill 480 by Chairman Hicks. We have a motion and a second. Chairman Hicks, you're recognized on House Bill 480.
Thank you, Mr. Chairman. Committee, House Bill 480. One of the most challenging tasks for surveyors is conducting retracement surveys on parcels of land with vague or poorly written legal descriptions in their deeds. The bill before you places the responsibility of drafting legal descriptions for newly created land parcels, easements, et cetera, on the surveyor to ensure accuracy and clarity.
Members have any questions? Any comments? Vice Chairman Wright, you're recognized on the bill, sir.
Thank you, Mr. Chairman. You said newly created parcels.
That is correct.
Just for legislative intent. Thank you, Mr. Chairman.
So any other questions or comments? Seeing none, is there objection to the question? Hearing none, we're voting on House Bill 480. Moving to the next bill calendar. Madam Clerk, open the voting rolls. Will every member vote? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
Thank you, Madam Clerk. The ayes prevail. House Bill 480 moves next available calendar of state and local government.
Thank you, Mr. Chairman and committee.
Next bill on today's calendar is House Bill 863 by Chairman Faison. Do you have a motion? We have a motion. Do we have a second? We have a motion, a second. Chairman Faison, you're recognized on the bill.
Thank you, Mr. Chair, committee.
You
I am
do
not-
have an amendment, is that correct?
Yes, sir. Well, we need to withdraw an amendment.
I believe the amendment
There's
is
somebody
five.
excited can you gavel this one out, please? And we'll take it.
House, you have amendment 5335.
I'm sorry. Committee, is there amendment currently on the, there's not. Okay,
5335.
that's the one I want to
It
put on.
makes,
We want to adopt that one.
There-
Settle down, sister.
Mr. Chairman, you're in the subcommittee. You know how this works.
Yes, sir. I just remembered. Whoever wrote my notes
5335.
down.
5335 is before us. Will you, is there questions or comments on the amendment? All in
Would the committee
favor,
like-
all
okay.
in favor of amendment 5335, say aye. Opposed, say no. The ayes prevail. We are back on the bill as amended. You're recognized on the bill, sir.
Thank you, Mr. Committee and Chairman. Thank you for your indulgence and putting up with me. I'm not an attorney. I am playing attorney today, and I'm going to give you a good legal term
On
that
the
you need to
bill.
remember. In perpetuity. That's the word I'd like for you to remember for today. Last year, previous General Assembly, we passed a law that cities and counties can set up incentives for low-income housing. And unfortunately, in the law we passed, we said whoever got the incentives, the developers had to keep their property for in perpetuity. We're just changing that to 30 years. And please do not recognize the gentleman from Davidson County. He's out of line.
Mr. Chairman, please. Representative Mitchell, you're recognized on the bill as amended, sir.
Thank you, Mr. Chair. And I will not ask Mr. Chairman what the definition of in perpetuity is, but this is our second attempt at this bill. Don't mess it up.
Sponsor, you're recognized
Thank you,
on the
Mr.
bill.
Thank you, Mr. Chair. If the gentleman from Davidson County can spell in perpetuity without looking, then I would.
Out of order. Is there any more comments or questions? Is there objection? Is there objection to the question? Hearing no objection, we're voting on House Bill 863 as amended. Madam Clerk, open the voting rolls, please. Let every member cast their vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
Thank you, Madam Clerk. The ayes prevail. House Bill 863 as amended moves to the next available calendar of state and local government.
My gratitude will go in perpetuitously from here on.
Next bill is House Bill 335 by Chairman Halsey. We have a motion and a second. You're recognized on House Bill 335. Do you have an amendment, sir?
Let me see. Yes, sir, I do. It's 5252.
We have a motion. Do we have a second? Do we have a second on the amendment 552? We have a motion and a second on amendment 552.
5252.
5252.
Yes.
Thank you, Chairman Halsey. Would you like to go ahead and put that on the bill, sir?
Please, sir.
Is there objection to the question? Hearing none, all in favor of amendment 5252, say aye. Opposed, say no. The amendment's on the bill. You're recognized on the bill as amended.
Thank you, Mr. Chairman and committee. I thought this would be a private act issue because what it is for the town of Bluntville is to allow the utility district to raise the pay for board members on the utility district from $300 to $500 a month. But Bluntville is the town of Bluntville, and it is the only town in the whole state of Tennessee that is a county seat, but it's not incorporated. And I don't know if that made a difference in how this got assigned to your committee or not, but that's what this bill deals with, and that's what we're trying to do.
Questions or comments for the sponsor? Is there objection to the question? Hearing none, we are voting on House Bill 335 as amended, moving to the next available calendar. Madam Clerk, open the voting board. Members, please cast their vote. Has every member voted? Has every member voted? We're in the middle of voting, sir. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
The ayes prevail. House Bill 335 as amended moves to the next available calendar, state and local government.
Thank you, Mr. Chairman. Thank you, committee.
Next bill on today's calendar is House Bill 795 by Chairman Vaughn. We have a motion. Do we have a second? We have a motion and a second. Chairman Vaughn, you are recognized on House Bill 795.
Thank you, Mr. Chairman. It seems like this year I've been carrying a lot of bills that have to do with things that can streamline processes around development and growth. And most of those are to, quite frankly, deal with the fringe elements of folks that may not be taking care of their business properly. And unfortunately, having to bring about state statutes to do that. One, this bill, House Bill 795, has 2 parts. One, it addresses performance bonds and how you get a standard procedure, requires communities to have standard procedures for performance bond release. It creates a uniform process by which typically this is spelled out in contracts, but not all contracts are the same. So what we're trying to do is make sure that performance bonds aren't held for unusual periods of time, getting into where they're basically, using my colleague prior, basically a warranty in perpetuity, since that's the element of today. The other is sites that, when we were just in state and local, we talked about with my friend from Davidson County about what is perceived as an appropriate development application, a complete development application. This sets a process up that says that municipalities, communities, counties, whoever, have to respond to an application within 30 days. And if they don't, they have to reply with a deficiency. And then if somebody replies, then they give them another deficiency. And after that, then somebody needs to have gotten something moved, because it keeps the constant, hey, I found something else out on your application. We can't accept it now because of this. We can't accept it now because of this. So what we're trying to do is condense this down to where it's a manageable, fair process for both parties involved. And again, whenever I mention this, this is something that folks who have their act together don't need this state law, but folks who do not have their act together, they do need the state law. And so we're trying to set the bar.
Thank you, Mr. Chairman. Thank you, sponsor. Is there any comments, questions of the sponsor? Is there objection to the question? Hearing none, we're voting on House Bill 795. Madam Clerk, open the voting rolls, please. Every member cast their vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 4 ayes and 3 noes.
The ayes prevail. House Bill 795 moves to the next available calendar, state and local government. Our next bill on today's calendar is House Bill 544 by Chairman Vaughn. Is there a motion? We have a motion and a second on the bill. Chairman Vaughn, you're recognized on the bill, except I have one question. This bill opens a number of titles. If there's an amendment placed on this bill, will you agree to bring it back, to refer it back to this committee?
Absolutely, Mr. Chairman. But better than that, let me tell you what it's going to do. And then I'll tell you.
I want to get that out of the way first. Now you're recognized on the bill, House Bill 544. Go ahead. Explain your bill, sir.
This is a concept that needs more fleshing out. quite frankly. It's only applies to cities that have a combined property tax rate of at least $5.50. It basically would be similar to an industrial development board, but it would be seeking to get abandoned commercial development parcels back on the tax rolls, and by providing an opportunity for decreased property tax rates while people reinvest and bring some of these blighted properties back on the tax rolls so they can actually become productive again. But again, it needs a little bit more work. And so we're going to be, let's see. I think I'll take it off notice so that I can recalendar it next year.
Thank you. Is there objection to taking this bill off notice? Hearing none. House Bill 795 is off notice. Thank you, Mr. Chairman.
Thank you, Chairman and Committee.
Excuse me. House Bill 544 is off notice. That's correct?
That's it.
Turn the page. It's 544. 795 is moving forward to state and local full.
Correct.
It's House Bill 544 is off notice. Next bill is, now we're back to item 2. We bumped someone. Chairman, Speaker Marsh. Is Speaker Marsh here? Without objection, we will roll Speaker Marsh to the heel. Hearing no objection, House Bill 832 is rolled to the heel. The next bill on today's calendar is House Bill 889 by Chairman Todd. I've just been informed that there's communication with the our office, that House Bill 889 is off notice. Next bill on our calendar is House Bill 1128 by Chairman Farmer. Without objection, House Bill 1128 is rolled to the heel. Next bill on the calendar is Joint Resolution number 2 by Chairman Darby. Do I have a motion? We have a motion and a second on House Joint Resolution 2. You're recognized on the resolution.
Thank you, Mr. Chairman. This ends the multi-year effort here to include in our state's constitution, the state of Tennessee should never collect a statewide property tax. Prior to 1949, Tennesseans were issued a property tax on the state level. Through this, the state acquired a lot of property as a result, especially during the Great Depression, as the property owners could not meet the additional financial burden. And with that, Mr. Chairman, I'll stand for questions.
You've heard the explanation of House Joint Resolution 2. Is there objection to the question? Hearing none, we're voting on House Joint Resolution number 2. Madam Clerk, open the voting board. Will members cast their vote? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
The ayes prevail. House Joint Resolution number 2 moves to the next available calendar, state and local government.
Thank you, Mr. Chairman and committee.
Next bill on today's calendar is House Bill 365 by Representative Fritz. Without objection, House Bill 365 is rolled to the heel. Next bill on today. Without objection, reconsider action, our previous action. Hearing no objection, we will now take up House Bill 365 by Representative Fritz. You're recognized. Is there a motion? Is there a second? There's a motion and a second on House Bill 365. You're recognized on the bill. Do you have an amendment?
Thank you, Mr. Chairman. Yes, I do. It's 5358.
Is there a motion on the amendment? Is there a motion on the amendment? Motion. Is there a second? Amendment dies for the lack of a second. Does the amendment make the bill?
The amendment does add some clarifying language with respect to the scope of the bill.
Does it rewrite the bill?
It does not fully rewrite.
You're recognized on House Bill 365.
Thank you, Mr. Chairman. House Bill 365 is simply
an intent to make sure that everybody has an equal voice and representation within their communities. This legislation in trying to bring about that equal representation, ensuring that people affected by actions of boards, councils, and commissions will have a voice in the decisions that these entities make. In Section 1, it requires that certain actions taken by a municipality that affect property owners in the county must be approved by the county commission as well before they can take effect. Section 2 and 3 address the way in which boards of economic development agencies are configured, as described in 658-114. It will require at least 90% of the board membership proportionately reflect the population of the communities they serve. It also requires that rules be promulgated to ensure compliance with this legislation and to ensure that the configuration of the board membership is adjusted following the release of the decennial census data from the U.S. Census Bureau. Why is this needed? Briefly, there are circumstances when a municipal legislative body, a subset of a municipal legislative body, or a board empowered by a municipal legislative body passes laws or sets a policy that affect citizens who live outside the city limits. These citizens have no opportunity in many cases to vote for the members of the municipal legislative body. Therefore, they end up being taxed or charged fees without representation. In my district, one of these cities has a water utility, my hometown. The board of water utility, or the board of that water utility, is made up of those elected to serve on the city council. This water utility provides water services to people who live outside the city limits in the county. The board passed a policy to charge any of their water customers with a property boundary that fell within so many feet of the sewer line for the use of that sewer line, regardless of whether or not they were connected to it. Current law does not prohibit this. Those in the county had and have had no voice in that decision and no ability to petition the government for a redress of their grievances about these fees, as well as the guaranteed First Amendment to the U.S. Constitution as guaranteed. Citizens who have refused to pay this specific fee for sewer services that they're not receiving have been in the past told that they'll have their water cut off that they do get from that city. Shortly after this legislation was filed, the water utility suspended those collection fees, and that's not an issue for those folks in my city now. But we feel like we need to address that portion of it. The second instance is with joint economic development boards. These boards were created by the General Assembly in 1998. They're a good thing, and with the intent that local governments engage in long-term planning. 658-114 sets general guidelines for establishing the membership of these agency boards, set a funding formula to support the EDAs and their initiatives, and required establishment of interlocal agreements. With no requirement to review or renew these interlocal agreements, it's likely that many of these EDAs are still operating under the same interlocal agreement they had in 1998. We know there have been a number of societal and population changes over the last 26 years. There's been a significant shift away from rural areas and into urban centers. In rural communities, there's been a shift off the land into towns and cities. Other factors such as annexation sometimes have changed these. The EDAs are funded by each of the participating governments. The amount each contributes is determined by a funding formula that is based on the percentage of the population in each one of those. This bill simply brings into congruence that funding as well as the per capita seating on the boards. With that, Mr. Chairman, I'll stop, take any questions you have, and ask for your favorable votes.
Thank you, Ms. Sponsor. Are there questions for the sponsor? Is there objection to the question? Hearing none, we're voting on House Bill 365 as presented. Madam Clerk, open the voting board. Every member vote? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 1 aye and 5 noes.
The noes prevail. House Bill 365 does not move forward.
Thank you, Chairman and Committee.
This time, the chair would like to reconsider action on House Bill 1128, being rolled to the Hill. Hearing no objection, that action is reconsidered, and we're now taking up House Bill 1128. We have a motion and a second on House Bill 1128. Chairman Farmer, you recognize. Do you have an amendment, sir?
Yes, I do. I believe it should be 4266.
Get on the right page just a moment.
It should be 4266, Mr. Chair, and I appreciate the committee's indulgence.
Okay, we do have a motion and a second on the amendment. You're recognized on the amendment, sir.
All right, thank you,
Can
Mr. Chair.
explain it?
And
Does it rewrite the bill?
It does. Yep. Okay.
So without objection, then, is there objection to the question on the amendment? All in favor of the amendment, say aye. Opposed, say no. The amendment, you recognize on the bill as amended.
Okay. Thank you, Mr. Chair. Members, over the break, I had one of my constables out of Jefferson County come to me and asked if I'd carry a piece of legislation that would allow them to obtain their post certification. He asked that they be required to have more hours of training, to be more involved in things that would make heighten their public safety awareness and just things that sounded real nice to do. So I took his suggestions and I drafted this piece of legislation, basically just ups the training for the constables, allow them to obtain their post certification. And that's basically it, members. So if you have any questions, I'll be happy to answer them.
Questions for the sponsor? Is there objection to the question? Hearing no objection, we're voting on House Bill 1128 as amended, moving forward to the next calendar of state and local government. Madam Clerk, open the voting rolls. Let every member cast their vote. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
The ayes prevail. House Bill 1128 as amended moves to the next available calendar, state and local government.
Thank you, Mr. Chair, members.
Takes us to the next item on the calendar, which I believe is House Bill 319 by Chairman Rudd. Without objection, we'll roll House Bill 319 to the heel. Hearing no objection, roll to the heel. Our next bill on the calendar is House Bill 636 by Representative Burkhart. Is there a motion? We have a motion and a second. Representative Burkhart, you're recognized. Do you have an amendment, sir?
I do, Chairman, 5353.
Is there a motion on, we have a motion, do we have a second? We have a motion and a second on Amendment 5353. You're recognized on the amendment. Does it rewrite the bill, sir?
Yes, sir.
Is there objection to the question? All in favor of Amendment 5353, say aye. Opposed, say no. The ayes prevail. You're recognized on House Bill 363 as amended.
Thank you, Mr. Chairman. What this bill does, last year, I believe Representative Crawford had, Representative Carr had this bill last year. And what this bill did, it's called the Rider Bill, and it was for residential properties. What we're simply doing is adding that permissive, and these are all permissive, but they can do commercial subdivisions as well as residential, and that's what the bill does.
We have questions for the sponsor. Is there objection to the question? Seeing none, we are voting on House Bill 636 as amended. Madam Clerk, open the voting roll. Every member cast their vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
The ayes prevail. House Bill 636 as amended moves to the next available calendar of state and local government.
Thank you, Chairman and committee.
Next bill on today's calendar is House Bill 79 by Representative Kiesling. Have a motion and a second on House Bill 79. Representative Kiesling, do you have an amendment on this bill, sir?
Chairman, we do.
And that is?
That amendment, let's check it out here. I'm showing 3681, sir.
We have a motion. Do
Is
we
that
have a
correct?
second? We have a motion and a second on Amendment 3681. You're recognized on the amendment. Does it rewrite the bill?
No, I don't think so. No, I've got some.
Is there objection to the question? Hearing none,
I can explain.
all voting in favor of amendment 3681, excuse
There
me,
you go.
say aye. Opposed, say no. Recognized on the bill as amended.
Well, let me explain. Yeah, I'll quickly explain the amendment. The amendment actually sunsets the act, which is relative to June 30th, June 2028. Now, after the sunset occurs, though, the municipalities who are approved for the revitalization will continue receiving those funds. This sunset applies to the application aspect of the bill. And finally, the third bullet point, it also changes the population. Right now, it reads 30, drops it down to 10,000, Mr. Chairman.
Members have any questions for the sponsor? Is there objection to the question? Hearing none, we're voting on House Bill 79 as amended. Madam Clerk, open the voting rolls. Every member cast their vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
The ayes prevail, and House Bill 79 as amended moves to the next available calendar, state and local government.
Thank you, Mr. Chairman and committee.
Always good to see you, sir.
Good to see you, sir.
Next item on today's calendar is House Bill 1083 by Representative Martin of Hamilton. Do we have a motion? Motion. We have a second. We have a motion and a second. Representative sponsor, do you have a amendment on the bill?
No, sir.
No amendment on 1083.
No, sir. Yes, just, hold on. I'm a little confused here. I apologize.
It's the first one on the calendar.
I got it right here.
On the Martin calendar.
That's right. Is that 5170?
That is what we have, sir. Is there a motion on the amendment? Motion. Is there a second? Second. We have a motion and a second on amendment 5170. You're recognized on the amendment, sir.
Thank you, Chairman and Committee. In a few moments, I'm going to take this bill off notice, but first I'd like to say a few words about this bill. House Bill 1083 came to me from my county trustee back in Hamilton County, and he told me that just in Hamilton County, there are approximately 18,000 personal property tax bills each year. Around 1/4 of these tax bills will total less than $20, and more than 5% will total less than $5. And in many cases, these bills are owed by small, often startup businesses, which utilize little to no personal property in their operations. Many of these businesses never commence operations or only operate for a short period of time before closing. Now, I'd offer this analogy. Would you continue printing 1 penny a cent if the materials cost you 3 cents to produce that penny? The trustees' collection costs well exceed the value of the initial tax bill, and many of these bills go unpaid. I've received feedback on the constitutionality of this bill after speaking with the Attorney General's office, and they have suggested this amendatory language to remove the provision which applied this only to Hamilton County while remaining permissive for any other local government to adopt. However, my trustee, Mr. Hallander, and I feel that this would be best to wait until all the Tennessee trustees had time to consider the language and bring the bill back next year. And at this time, I request it be taken off notice.
Thank you, Mr. Sponsor. We did have a pending motion, though, to amend this. So let me, all in favor of amendment 5170, say aye. Opposed, say no. The ayes prevail. Now we'll take up, you request to take this off notice. Is there objection? Hearing no objection, 1083 is off notice. The next item is House Bill 783 by Representative Martin of Hamilton. You're recognized on the bill, sir. Do you have an amendment?
I do, sir.
Wait, is there a motion on House Bill 783? We have a motion and a second. Now, do you have an amendment?
Yes, sir, Mr. Chairman, I do. It is number 5904.
Is there a motion? There's a motion and a second on the amendment 5904. If you'll explain the amendment, sir. Does it make the bill?
It does.
All right. Is there objection to the question? All Members in favor of Amendment 5904, say aye. Opposed, say no. The ayes prevail. House Bill 783 is amended, and you're recognized.
Thank you, Chairman and Committee. House Bill 783 came to me from a worried mother in my district. A sober living home in her neighborhood is also located 2 houses away from Hickson Elementary. One morning, a Jeep was parked outside of this sober living home, and when one of the residents left the home, the driver of the Jeep drove by and shot and wounded that resident in front of the children as they were walking to school at that time. This mother had filed multiple complaints with local elected officials, including for a residential harassing her on her property. Since May of 2019, there have been 10 calls of emergency services related to auto theft, overdose, and others at this residence. This particular home does not require a supervisor to be with the residents. It does not provide a formal treatment service, and neighbors are left with no accountability. House Bill 783, as amended, would offer local government tools to ensure the safety and the accountability of these sober living homes for both residents and their neighbors. This bill does 3 things. First, future sober living homes located close to a school or a daycare should be certified and adhere to minimum standards in our state. Local governments may choose to require these homes get certified with the best practice organizations. Second, local governments may regulate these home operations, including applicable health, safety, and building codes. And lastly, the local government could require that residents of these homes receive a referral or a recommendation from a licensed healthcare provider or recovery court. Any decision made by the local government would need to comply with the Federal Fair Housing Act and the American with Disabilities Act. And this bill does not aim to harm those seeking recovery. This bill does aim to hold sober living home operators accountable. And lastly, I want to thank Commissioner Williams for her feedback for this language, and I will continue to work with her and her team as we're going forward. And thank you, Mr. Chairman and Committee, and I stand ready for any questions.
Thank you, sponsor. At this time, we have 2 people that wish to speak on this item. So without objection, we'll go out of session. And our first speaker is Scarlett Bowman. If you'll come forward, please. If you'll have a seat. Yes, ma'am. And if you'll give your name, and if you're with an organization, if you'll give your name and that organization, please.
Yes,
Thank
Mr.
you.
Chairman. My name is Scarlett Bowman, and I'm with the launch pad of Chattanooga, Tennessee. 3 minutes, yes, sir. Well, I've prepared something that's right at 3 minutes. Mr. Chair and committee, I'm grateful for the opportunity to speak to you today. As stated, I'm Scotty Bowman, and I represent the launch pad of Chattanooga. We are a sober living community in Chattanooga with 5 houses currently, and that houses 50 women at a time. Currently, we have 44 residents, and they represent 90 children. Our residents are all women, and we feel like women are the backbone of the American family. If we heal the mother, we heal the family. I myself have 23 years in recovery. During that time, I've established 3 successful restaurants in Chattanooga. I also founded the launch pad in year 18 of my sobriety. Our focus is to give a hand up to reconcile families, livable wage jobs, and affordable housing. We offer wraparound services that address the woman as a whole. We try to keep them in the solution, not the problem. We're in the midst of a nationwide opioid overdose epidemic. Tennessee ranks second among all states with 56.6 deaths per 100,000 per year. Only West Virginia has more. The opioid abatement money was given to states in hopes of saving some of these lives that we lose every day. Unfortunately, I feel that the language in this bill will make the path to recovery even more difficult and thus cost lives. The distance to school requirement seems punitive in nature and further stigmatizes addicts and who are trying to recover. It likens us to violent and felony sex offenders and in essence criminalizes recovery homes. Additionally, our residents come to us with little more than the clothes on their backs. They often have no identification, much less the resources to receive a medical referral to live in our homes. To highlight their hardships is a way of shaming those who try to find recovery. As a businesswoman and founder of this program, I'm well respected in my community. It could have been a much different outcome had I not received grace instead of shame. Sober living houses save lives. There's no other way to say it. The launch pad is saving lives, one mother, one sister, one daughter at a time. When we're raising our babies and they're 8 years old, we don't think we're going to find them face up in a ditch 10 years later, but we do often. Addiction does not discriminate and it knows no boundaries. I feel it could be one of your daughter's lives we save the next time. Thank you for your time.
Thank you, Ms. Bowman. Our next speaker is Sammy Hartley. If you'll come forward, please. If you'll give your name and if you're with an organization, that organization for the record. Thank you.
Thank you, Mr. Chairman. My name is Sammy Hartley, and I'm with Oxford House.
You're recognized for 3 minutes.
Mr. Chairman and members of the committee, my name is Sammy Hartley, as I stated, and I'm with Oxford House, Inc. Oxford House is the largest recovery residence model in existence. Research funded by the National Institute of Health has clearly demonstrated that Oxford houses produce long-term abstinence rates of 86.5%, unequaled by any other addiction intervention. Oxford House is considered the gold standard of evidence-based recovery housing. Oxford House, Inc. has been contracting with the Tennessee Department of Mental Health and Substance Abuse Services for the last 12 years, now serving 173 homes with 1,343 beds throughout the state of Tennessee. According to OHI's General Counsel, a leading authority on fair housing law, all three powers this bill would grant local governments are clear violations of the Federal Fair Housing Act. Oxford houses are residential, non-commercial dwellings in which individuals choose to live together to support each other's recovery by following the tried and true Oxford House system of operations. Requiring clinical referrals indicating medical necessity restricts people's ability to access care. The majority of individuals early in recovery often have no insurance, no healthcare provider, and very limited resources. This referral requirement, in addition to being inappropriate in such non-clinical residential settings, would also certainly violate the FHA. If Tennessee and its local governments wish to ensure the highest standards of safety and quality of sober living homes through certification and other regulations, there are proven ways to successfully do that. On behalf of OHI, the Oxford House of Tennessee houses, and the recovery community as a whole, I wish to express our opposition to HB 0783. On a personal note, I would like to add that the Oxford House that I started my journey in 7.5 years ago was located right next to an elementary school. It was also located right next to a church daycare center. We've never had any incidents at that particular home, and the house directly across from us is actually the problem home in the neighborhood, and it is a private residence as well. Thank you for your time.
Thank you, Mr. Hartley, for your testimony. We'll go back into session. Representative Dixie. Mr. Hartley, if you'll please come back, please, to the microphone. Just a moment. Representative Dixie, you're recognized.
Thank you, Mr. Chairman. Thank you for being here. Thank you for your testimony. I just had a quick question. We talk about the residents and referral. How do you get the residents now? Or it could be for the other person that testified.
Mr. Hartley, you're recognized.
Okay, so we do have, Oxford House has a website that's available where people can find the contact information for the individual houses. We do receive referrals from different agencies, whether it's a counselor, whether it's the courts, the jail system, treatment centers, even just family and friends who have maybe come through our program or know someone who have referred people to us. Myself, I came out of the Knox County jail system, and I'd sat there for 7 months. I'd been a repeat offender who would go in and out of the jail system, and I never ever knew that there was something that existed that you could move into voluntarily without having to have a court order or without having to have a medical referral. And so I had never tried to go into a program. I'd asked for it through the courts, but had never been granted that. However, when I did find out that you could go to this Oxford House without having a referral, that's what I chose to do. By putting these referrals in place, what we're doing is we're preventing people from making the conscious decision to get their lives together on their own. And we're putting another barrier to that problem.
Representative Dixie.
Last
Representative
question.
Dixie, you're recognized.
Thank you, Mr. Chairman. So my last question, is there a cost to this?
Mr. Hartley, you're recognized.
To the residents, sorry.
So all of our Oxford houses are financially self-supporting. We receive no grant money. We receive no income from any other resource. All of the money that is generated within each house comes from the members living in the house. So they pay a non-refundable move-in fee, and then they pay a weekly amount. Depending on the location, that varies a little bit, but right now it averages about $150 per week. And that includes all of the utilities, the fully furnished house, including in their bedroom area, a bed, dresser, nightstand, lamps, so forth. We also provide all the bedding. We provide all the cleaning products, paper products, laundry detergent. We have a house phone for everybody's use, as well as Wi-Fi. And these people, the members, they bring their money order once a week to their weekly house meeting, and each person in the house holds a position. You have your house president who runs the meetings. You have your treasurer who keeps track of the bank account. You have your comptroller who takes track of those payments that those members have brought in. And then we also have a coordinator who assigns chores and makes sure the safety issues within the house are handled. So there's a position for everybody in the house. We call it a voice and a choice. The money that comes in that house meeting goes into that house bank account for that specific Oxford house. And at that same business meeting, they write out those checks to pay those bills, to pay the landlord, to pay the electric company, to pay the water utility, and so forth. They also do their own store runs to make sure that all the cleaning products and paper products and everything are available. And they go to Walmart and they do their own shopping. They do the house check through that. So everything is paid directly out of that house account. There is no money generated whatsoever to Oxford House Inc. from the independent houses.
No, you're not recognized. Thank you for your testimony. We're going back into session.
Thank you.
Representative Martin, you're recognized on the bill, sir, as amended.
Thank you, Mr. Chairman. A couple things that I would say. Any house that is in relation to a church or in relation to a school is grandfathered in at this point. This is completely permissive for local and county governments. And the last thing that I would say, it's really important, is in section 1, letter B, the ordinance of the resolution adopted pursuant subsection must comply with the Fair Housing Act as amended and the Americans with Disabilities Act. So we're not asking to do anything that is a violation of federal law. And that's one of the reasons we have talked with the Attorney General to make sure that we are in good standing with regard to this. And with that, I'll be glad to take any other question.
Questions for the sponsor on House Bill 783 as amended? Chairman Littleton, you're recognized.
Thank you, Mr. Chairman. As you know, I've worked with this for about the last 6 months, but the ADA, can you tell us how that approves all that's in this bill, that they do approve it and they'll?
Representative Martin, you're recognized.
Well, it gives permission to local governments to set some parameters. And so they cannot set anything that is going to violate the ADA or the Fair Housing Act.
Chair Lady, you're recognized. Follow up?
No, thank you.
Any other questions? Any other comments? Is there objection to the question? Seeing, hearing none, we're voting on House Bill 783 as amended. Madam Clerk, open the voting board, please. Every member cast their vote. my voting, Madam Clerk? I'm not coming up to vote. I've got pause meeting or stop meeting. And I desire not to do either one. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 783 as amended moves to next available calendar, state and local government. Thank you. Did I see Speaker Marsh? Okay, the next bill on today's calendar is House Bill 1161 by Representative Stevens. Without objection, this bill is off notice. Hearing no objection, House Bill 1161 is off notice. The next bill on the calendar is House Bill 405 by Representative Leatherwood. Do we have a motion? We have a motion and a second. Representative Leatherwood, you're recognized on House Bill 405. Do you have an amendment, sir?
Yes, sir, I do. 4762.
We have a motion. Is there a second? Is there a second on amendment 476? We have a motion and a second. All in favor of the amendment say aye. Opposed say no. The ayes prevail. You're recognized on House Bill 405 as amended.
Thank you, Mr. Chairman and committee. This bill requires a hotel operator to remit the hotel occupancy tax to the municipality when a person has maintained occupancy for 30 continuous days and then to cease collecting the tax from the person for the remainder of their stay in the operator's hotel. And with that, I appreciate y'all supporting.
Members, you've heard the explanation of the bill as amended. Are there questions for the sponsor? Is there objection to the question? Hearing no objection, we're voting on House Bill 405 as amended. Madam Clerk, open the voting rolls, please. Every member cast their vote. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 1 no.
The ayes prevail. House Bill 405 as amended moves to next available calendar, state and local government.
Thank you.
The next bill on today's calendar is House Bill 1279 by Representative Hill. Without objection, House Bill 1279 is off notice. Hearing no objection, it's off notice. Next item on today's calendar is House Bill 48 by Chairman Hale. We have a motion? Do we have a second? We have a motion and a second on House Bill 48.
Motion.
We have a motion and a second already. It's in proper posture before us. You're recognized on House Bill 48, Chairman Hale.
Thank you, Chairman and committee. Miss being on this committee, by the way, with you, Chairman. So House Bill 48, this legislation would remove the market value cap on property tax relief for disabled veterans. Present law caps the relief to the first $175,000. This bill would remove the cap and would be at 100% of the value. There's basically, I think, 20 states that's already doing a similar tax relief for disabled veterans. And the goal of this legislation is just to provide another way for our state to show gratitude to those who have sacrificed so much for our nation.
You've heard the explanation. Are there questions for the sponsor? Is there objection to the question? Hearing no objection, we're voting on House Bill 48, moving to the next available calendar, state and local government. Madam Clerk, open the voting board, please. Every member vote? Does every member cast their vote? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
The ayes prevail. House Bill 48 moves to the next available calendar, state and local government.
Thank Thank you, Chairman and Committee.
Mr. Chairman Hale, before you leave, the next item on the agenda is House Bill 366. You're recognized.
We're taking that off notice, sir.
Without objection, hearing no objection, House Bill 366 is off notice.
Thank you.
Next bill on today's calendar is House Bill 622 by Representative Mayberry. We have a motion, a second. Representative Mayberry, you're recognized. Do you have an amendment, sir?
I do.
If you'll give us that amendment number.
I got amendment number 5791.
5791, we have a motion. Is there a second on the amendment? Is there a second? We have a motion. Do we have a second? Second. We have a motion and a second. You're recognized on the amendment 5791. Does it rewrite the bill?
Yes, it rewrites the bill.
Okay. Is there objection to the question? All in favor of amendment 5791, say aye. Opposed, say no. The ayes prevail. We're back on the bill 622 as amended.
Thank you, Mr. Chairman. House Bill 622 prohibits state, county, municipal, and local governments, LEAs, and public higher education institutions in Tennessee from making hiring decisions based on diversity, equity, and inclusion. The bill mandates that hiring decisions must be solely based on merit, focusing on qualifications, experience, and skills. Also, no particular candidate can be hired in order to achieve any goals to increase diversity, equity, or inclusion in the workplace. I stand ready to answer questions.
Thank you for the explanation. Sponsor, at this time, we have two people that wish to give testimony on House Bill 622 as amended. The first person is Megan Cohen. If they're available, if you'll please come forward and have a seat at the table. And if you'll give your name and if you're with an organization. Your name is, please.
My name is Megan Gohane. I'm from Robertson County.
Thank you. You're recognized for 3 minutes.
Thank you, Chair, Committee, and Sponsor. I work retail and I want to share 3 experiences. A customer was in an aisle looking at product. I asked him if he needed help. He started to answer yes when another associate, a young man in his 20s, turned the corner. The customer stopped talking to me and said he would ask the man. He didn't know that at that point I had worked in the store for years and was the area specialist. Young man was in his training in his first 30 days, but he assumed the man would be better able to answer his question. A second example is my sister's. A customer called for a manager. When she approached, he told her, no, I wanted a man manager. The third experience, a customer purchased multiple heavy items. My sister answered the page to load, and the customer told her that if she loaded his car, he would rather return that product. The customers in story 1 and 3 were not trying to be rude, but preconceived ideas about what a woman could or should be doing caused them to make judgment calls that neither I nor she would be able to assist. What they didn't realize is their actions were saying, I couldn't do my job. I picked those stories because I want to make sure you understand that it is well-meaning and good people that have biases that they don't realize. I want to take a moment to look at the specific words and what they mean. Diversity can be multiple factors: race, gender, economic status, rural versus urban, education, culture, age, and much more. It means getting a broader pool of individuals. Equity simply means leveling the playing field. Inclusivity can be programs aimed at increasing and celebrating specific groups, with one of the most common initiatives, especially here in Tennessee, being hiring veterans. Many assume diversity, equity, and inclusion mean unqualified, like the customer in story 2, who saw a woman and assumed she couldn't help him. There's a phrase that beauty is in the eye of the beholder. Well, if you see a member of a minority and question whether they belong in that role or if they were hired because of DEI, then the unfounded assumption is also in the eye of the beholder. I have more examples from this very building. February 19th in State and Local Government Committee, I watched Representative Parkinson speak about the song Tennessee by Arrested Development being named a state song to Tennessee. The committee voted no. That song may not have meant something to them, but it did mean something to other Tennesseans. But they didn't recognize a moment of diversity or inclusion in front of them when it was presented by one of your own peers. Last year on the House floor, Representative Ben entered a bill to consult other religious holy days when building out a legislative calendar, and it was turned down. It failed because a chance to consider an equitable process was not recognized. Last week, in the Public Service Subcommittee, HB 333, a bill to encourage diversity by allowing aging firefighters to continue to serve in leadership positions passed. This committee passed HB 765 and 766, which are examples of equity in dealing with property tax. And the Agricultural and Natural Resource Subcommittee passed HB 646, an example of inclusion. You mean to be outlawing the boogeyman that DEI has become in common parlance, but you don't mean to be outlawing diversity, equity, inclusion. You do innately recognize these are good things, but we all still sometimes need assistance seeing that. And that is why programs that emphasize diversity, equity, and inclusion are sometimes still needed.
Thank you for your testimony. The next person we have on the list is Monica Meeks. Not seeing her. Thank you. We'll go back into session. Representative Mayberry, you're recognized on your bill as amended.
I renew my motion.
You renew your motion. Is there objection to the question? Yes, Representative Mitchell, you're recognized.
Yeah, thank you, Mr. Chairman. You know, we're hearing a lot about this, especially in the federal government. And, you know, just this morning, before I even knew this bill was going to come up, I saw a news story, and it was about the Department of Defense had taken down a web page about Jackie Robinson. So, you know, I knew Jackie Robinson served in the military. I was like, well, Ted Williams, he served in the military too. I wonder if they got a page about Ted Williams. So I just Googled Ted Williams. Wow, Ted Williams' page still pops up on the federal website. You know, it tells all about his accomplishments in baseball and his accomplishments in the military. What's the difference between Ted Williams and Jackie Robinson? Not much in baseball, not much in their military accomplishments. So I'm just hoping that through all this, we're not giving a license to something else. And if we're doing that, God help us, God help this state, and we're going backwards. But like I said, there ain't much difference between Ted Williams and Jackie Robinson in baseball nor military service. I don't know why one's still up and one's down. So, you know, I don't know what you're trying to accomplish, but I hope it's nothing about going backwards in time into the good old days or a time when America was great at some point in time, but it wasn't great for everybody.
Representative Mayberry,
Thank you, Mr.
you're
Chairman.
recognized.
Yeah, thank you, Representative Mitchell, for your comments and question. This bill's about hiring practices and to make them merit-based, and that's simply what this is about.
Representative Dixie, do you desire to be recognized? You're recognized. You're recognized.
Okay, thank you. Sorry, I was looking for something real quick here. I think there's a misnomer, and we've had this conversation many times, especially this session, about what DEI means, who it impacts, and who it works in favor for, who it doesn't work for. And we do a lot of stuff, and we had a person come up here and testify. There just happens to be a white woman. And we have to understand that it takes all of us to make it better. Are you familiar with the term cultural competency?
Representative Mayberry.
Please share.
The question was to the sponsor. So you recognize.
Yes, thank you, Mr. Chairman. Representative Dixie, please share what you would like to share.
You recognize Representative Dixie.
Thank you, Mr. Chair. The goal of cultural competence is to understand how people act and how you relate to people in certain situations, especially when they're in a classroom. In a previous life, I was an internal auditor for the Department of Education. That was my first job out of college. And when I went to East Tennessee, there were very few Black kids there, but they were disproportionately suspended or punished as opposed to their white counterparts. Now, when you move to West Tennessee, it was a little bit more even. It was more balanced. And I'll tell you why it's important. I would have a high school, actually, that Representative Love went to, which is in my district, Whites Creek High School. I went there to visit. And when I went there, I noticed it was a lot of my classmates who I grew up with were there teaching. And, you know, that school is doing great, and they have low suspension rates and low behavior problems. I mean, it's because the people who are teaching there knew their families, They came from the communities, and they purposely recruited those people for those positions, and race was a factor, and it produced better outcomes. So I don't understand, or maybe you can tell me how dismantling the DEI Act, which the title is offensive in itself, how is this bill going to make or strengthen hiring practice when part of your bill that strips out one of the sections doesn't strengthen hiring practices at all?
Representative Mayberry.
Thank you, Mr. Chairman. This bill's pro-quality. It's not anti-diversity. We welcome diversity when it happens naturally through merit-based hiring practices. When we are opposed, or what I'm opposed to, is a forcing any type of goal set that is connected to characteristics. So this is merit-based, not anti-diversity. Diversity happens naturally when it is merit-based.
Representative Dixie.
Mr. Chairman, I wholeheartedly disagree about diversity happens naturally. If we waited for diversity to happen naturally, Black people still wouldn't have the ability to vote. We wouldn't have some of the protections that we have. You know why we don't have them? Because when you have to force people to do the right thing sometimes. There are some people that will do the right thing sometimes, but it doesn't happen naturally. And there's a quote from the U.S. soccer team in 2020, ladies soccer team. Change doesn't happen unless it has to. And so for you to, it's almost laughable about your arguments that you have and even bringing this bill to say that diversity is going to happen naturally. It's never happened in the history of this country. So why would it happen now? It's more divisive now than we have been in the last 60 years. And this bill attempts to roll back some of the progress we've made over these last 60 years. And I just don't understand your goal of it. And again, I just want to reiterate the title, Dismantle DEI Act. So to you, what does DEI mean, and which part of the D, which is diversity, E is in equity, or I is inclusion, offends you?
Representative Mayberry, you're recognized.
Thank you, Mr. Chairman. And again, thank you, Mr. Representative Dixie, for your comments and questions. Diversity, equity, and inclusion. I have no problem with the words diversity, the word equity, the word inclusion. Diversity, a group of people there. Equity, fairness, inclusion, bring everybody together. What it's become is becoming an ideological, political football that has been used for politics. This bill will align our state to have fair hiring practices based on merit. This bill will not also, as your comment you made, this bill will not eliminate protections against discrimination. It simply ensures that hiring decisions are made based on qualifications. There's already protection in the law against bias in hiring in Title VII of the Civil Rights Act of 1964, and that prohibits employment discrimination based on race, color, religion, sex, and national origin.
Representative Dixie, follow up.
Thank you. Thank you, Mr. Chairman. I appreciate your leniency on this conversation. I really do. You made a statement that it has become political. Not one person in this House, this General Assembly, from my party, Democratic Party, has brought a bill that has DEI in it. So for you to say it's become a political football, I think it's your party that is pushing this agenda and making it a talking point when it's, again, a solution in search of a problem, which there is no problem, which guarantees that more people will be involved in the process other than white men. So we have to be inclusive. These laws were in place for a reason, because people were being excluded because they weren't part of the in crowd or the decision makers or sitting at the table, or whatever acronym you want to use, or what kind of analogy you want to use. That's why these protections are in place to begin with. I just wish you would think through this a little bit. Don't be so partisan on this to make sure, is this good for our kids? Is this good for our students? Is it good for our state? It's not. The more inclusive we are, the more different views we have, the more different opinions we have, the more different lens that we look through things is how we become a better society. Again, my colleague to the left of me said, where are we going back to? What is the great time that we're going back to? And I feel like there's no need for this. And if you say that it's not going to change anything, it's based on merit, what's the point? Because your people are already being hired on merit and need. And also, just to throw in, we do have a teacher shortage, and I don't understand how this is going to help. So if you can explain to that, how would this bill help the teacher shortage?
Representative Mayberry.
Thank you, Mr. Chairman. The reason this bill came about is I was simply sitting inside of a city council meeting in which there is a diversity, equity, and inclusion position. And the city council was debating about how to define it potentially, ultimately did not pass. And I sat there and just simply thought, well, I can do something about this. Since then, I've had lots of other counties reach out to me about, from school boards to cities to other areas that have said, hey, we have DEI inside of our government entities, and we would like for it to get out. I've also had multiple professors from multiple colleges reach out to me saying that within college systems, DEI hiring practices have harmed their ability to advance in their jobs. I've also had someone that identified as a Democrat who emailed me saying that they're typically against all Republican bills, but they're for this because it actually has happened to them. So I've had multiple outreaches since putting in this legislation, and I've seen it within the government throughout Tennessee, which is one of the reasons I brought this forward. And last night on the school board meeting, which I sit on the school board in a county here in Tennessee, this topic got brought up, not by me, about teacher shortages. And I directly asked the district, how many openings do we have? And at that point, they talked about how all the openings we have. And I said, hey, if we have a qualified person applying to become a teacher in this district, are we turning them away? They said no. So it's not going to affect teacher shortages.
One more.
Right.
You're recognized, Representative Dixie.
This is the best committee I ever had.
You're recognized.
Thank you. I just wanted to just finish with this. You pride yourself on being a Christian and a part of a pastor. And look at this bill. And just last question. Is this Christian-like, and what would Jesus do?
Representative Mayberry, you're recognized, sir.
Thank you, Mr. Chairman. Yes, I'm a pastor. I pastor at the most diverse church in my community and one of the most diverse churches in the entire state, I would imagine. It's a large church. We do not follow DEI practices on our staff, which our staff is incredibly diverse. To those who are above me, not being my race. The teams that we have, varying people with different backgrounds and people that are in charge of different groups. And the best person qualified for those positions are in those positions. And it's based on merit. And so that's what this bill will do, to align our state standards and hiring practices based on merit.
Representative Littleton, you're recognized.
Previous question.
Is there objection to the question? Is there objection to the question? Hearing none, we're voting on House Bill 622 as amended. Madam Clerk, open the voting rolls, please. Will every member cast their vote? Does any member wish to, all members voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 622 as amended moves to next available calendar, state and local government.
Thank you, Chairman Committee.
Next bill on our calendar is House Bill 426 by Representative Love. You're recognized on your bill, sir.
Thank you, Mr. Chairman.
Thank you. Thank you very much.
I do want to again acknowledge.
This is a long meeting, and I appreciate any help I can get. Thank you. Your proper posture now.
Thanks, sir. Just want to give the committee a history of this bill. I had a constituent of mine who has a religious institution that moved from one location to the other. And when they built the new facility, they erred and did not apply for the exemption.
Do you have an amendment on this bill, sir?
Yes, sir. The amendment is 005458.
Is there a motion on Amendment 5458? Is there a motion and a second on Amendment 5488? Does it rewrite the bill?
It does, Mr. Chairman.
Is there objection to the question? Hearing none, we're voting on Amendment 5458. All in favor say aye. Opposed say no. The ayes prevail. Your bill is amended.
Thank you, Mr. Chairman. So I was trying to narrowly focus it to that one institution. Upon having conversations with other people, realized that across the state, several times institutions may relocate, and again, no fault of anyone else, but the application for exemption does not happen, and they end up with taxes that they thought were exempt. And this institution then has to try to figure out how to either raise that money or find some appeal process. So amended it again to try to have religious institutions that may move, sell the property and build a new location, or move or add on to the facility to be able to have an exemption that follows the organization. Of course, I know there's some challenges with this, and the amendment is not where I'd like for it to be, but I just want to give members a history of how this got to be. This actually happened to me when I got sent to my current church. We were facing one street and then built the church facing a different street and got hit with a huge property tax bill because we forgot to apply for exemption on a different street, even though we're on the same piece of property. So just trying to help out some of our institutions that from time to time, Mr. Chairman, I think we've talked about instances where the chairman of the deacon board or the steward just sees the tax bill and says, well, we're exempt, so we shouldn't be paying this because we're exempt. Happened to a sister church of ours in South Nashville, where a piece of property they had, they weren't paying that much on the property taxes, but then when the neighborhood began to change, property values went up, and they got a $25,000 property tax bill, all because they did not apply for the exemption. So I know there's some concerns about it, and I've told a great many friends that I'd like to roll this bill. I know I've rolled and rolled and rolled and rolled and rolled, and so I think it's going to go to the special calendar and have to be brought back up next year.
So, sponsor, it has been calendared 3 times. So at this time, this bill will be moved to the special calendar, which will be heard at the heel of this calendar.
Thank you, Mr. Chairman and committee members.
Our next bill is House Bill 92 by Representative Hardaway. Without objection, we'll roll House Bill 92 to the heel. The next bill on the calendar is House Bill 993 by Representative Hardaway. Without objection, we'll roll House Bill 993 to the heel. The next bill on the calendar is House Bill 930, and I understand Chairman White is the sponsor. Is there a motion? Motion and second on House Bill 930. Chairman White, you're recognized on House Bill 930.
Thank you, Chairman and Committee. This is the one, this was kind of handed to me last minute. The person that was carrying it is no longer. And they asked if I would just present it. And so I think I know enough to be dangerous. But here's what I understand this particular bill, what they're trying to do. In 1986, there was through the Tennessee Home Builders, there was a loan fund that was created called the Home Buyers Revolving Loan Fund. And what they did, this fund was designed to establish to make loans to the low and moderate income persons in areas in which critical housing needs for the purpose of securing residential housings for such persons. Well, 1986 was 39 years ago, and what I'm being told is that there's $3.1 million locked down that they cannot access anymore because in 1899, the statute that was created to govern this particular program, higher interest rates and things. And so there's money there, but the developers today cannot get to it through this fund. So I am told through the language in this particular amendment that I have before you, Bill, is that this unlocks where developers today can access this revolving fund again for low-income housing.
Mr. Sponsor, I don't show an amendment on this bill.
I didn't mean amendment. It's
The language of the bill 930 speaks to what your explanation was, I believe.
correct. Yeah.
Questions? Questions for the sponsor? Representative Dixie, you're recognized.
Do you know how much is in this fund?
They're telling me it's 3.1 million approximately sitting in there that been there for a while, and they just cannot access it unless we update the statute which we're trying to do in this bill.
Representative Dixie.
Is this for all across the state or?
I understand it's a revolving fund that each county can request a fund from across the state, like one of these, one fund.
Thank you, Mr. Chairman.
Any other questions? Any other comments? Is there objection to the question? Hearing none, seeing none, we're voting on House Bill 930. Madam Clerk, open the voting roll, please. Every member cast their vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
The ayes prevail. House Bill 930 moves to next available county, state, and local government.
Thank you, Chairman. Committee,
Thank
appreciate
you.
that.
Next bill on today's calendar is House Bill 742 by Representative McKenzie. Without objection, we'll roll House Bill 742 to the hill. Hearing none, House Bill 742 is rolled to the hill. Next bill on today's calendar is House Bill 1381 by Representative Harris. Representative Harris, you're recognized. I believe you have an announcement.
Oh, I was like, wait, what's going on? Thank you, Chairman. House Bill 1381 is being taken off notice.
Without objection, hearing no objection, House Bill 1381 is off notice. The next bill on our calendar is House Bill 1380 by Representative Harris.
There we go. Thank you so much, Chairman. And I have an amendment.
We have a motion, a second. Representative Harris, do you have an amendment on this bill?
I do. 005548.
Amendment number 5548. Is there a motion on the amendment? Is there a second on the amendment? We have a motion, a second on the amendment. It was properly before us. Would you like to explain the amendment? Does it rewrite the bill?
It does not rewrite the bill.
Okay,
It just
go ahead and
adds-
explain the amendment, and then we'll take a vote on the amendment.
Awesome. Thank you so much, Chairman, and to the committee. This amendment would add 5 words and requires the taxpayer signature to the actual legislation.
Is there objection to the question? We are voting on House Bill, on the amendment 5584. All in favor, say aye. Opposed, say no. The ayes prevail. You're back on the bill as amended. If you'll explain the bill as amended, sir.
Thank you so much, Chairman, and to the committee. House Bill 1380 is a bill that would simplify the property tax relief process for some of our most vulnerable citizens, seniors aged 85 and older who have consistently qualified for relief over the last 5 years prior to. Under this legislation, these long-term participants can reaffirm their eligibility with a simple checkbox process rather than navigating redundant paperwork every single year after they have already been doing it for multiple years in a row. This would still require that they have to actually put their physical signature in an effort to make sure that there's no fraudulent work happening. I actually used to work in the trustee's office in Shelby County, and so I know how this process works. And this has actually been something that was approved and voted on by our trustees association for the state. So with that, I will entertain any questions.
Any questions or comments for the sponsor? Vice Chairman Wright, you're recognized on the bill as amended, sir.
Thank you, Mr. Chairman. So I heard you say they had to sign, this is an annual redeclaration, right?
Representative Harris, you're recognized.
Thank you so much, Chairman. And that is correct. So basically what has to happen is they do an application process. That application comes to the state. The state has to approve the decrease in or the coverage of the tax cost. So it's a process that they have to go through. Typically what they do is they provide documentation like pay stubs or financial records and all that other good stuff. So this simply would just make sure that if they have been doing it consistently for so many years, that part of the process they don't have to continue.
Vice Chairman Wright.
Thank you, Mr. Chairman. And under penalty of perjury, this signature of the property owner has to be witnessed.
Representative Harris.
So it does not have to be witnessed. There's currently right now, the application that the state provides is you can either do it online in some cities, but you can do it paper wise as well. Most trustees end up mailing you out a paper application, and usually individuals will do it that way. Most individuals over the age of 85 aren't doing it online. So
Representative Harris, and I think this goes, go ahead, Vice Chairman Wright.
Thank you, Mr. Chairman. So I think I'm asking a sort of technical question. Could we go out of session and ask legal about the property owner making a signature, and does that have to be witnessed?
Without objection, we'll go out of session. Legal, if you'll entertain this question.
Thank you, Mr. Chairman. Josh Houston, Legal Services. The bill does not specify, and I'm looking in the code for those provisions, and I don't see anything in the provisions for this tax relief that requires the signature to be witnessed by anyone.
Any other questions for legal while we're out of session? Vice Chairman Wright, are you good? Without objection, we'll go back into session. We're back on the bill as amended. One question, what is your intent of this bill is to allow someone 85 years or older to continue to make application, but not submit the supporting documentation. Is that correct?
that is correct. So they already have been doing and submitting that same documentation for the last 5 years prior to. So it's already consistently being done for them. It's just that moving forward after 5 consecutive years, they wouldn't have to continue providing those additional documents. They still have to complete the application. They still go through the approval process. None of that changes. It's literally just the additional documentation that is provided.
Vice Chairman Wright.
Thank you, Mr. Chairman. I think I'm bumping into a problem here. I was looking for legislative intent, and I think I'm going to need the mark of the person that owns and then someone witnessing that on an annual basis. And I would hope that the form, and I see our legal services are still searching the background here, but I think for me to get past this on this bill would be the person has to apply and someone has to witness their signature.
Sponsor, you recognize the question.
So currently, with all the applications now, there's no process for them to actually have to provide a witness at this very second. But what I will suggest, though, is that so that way I can be able to provide you with the application that they currently fill out. I would ask to be able to roll this a week so that way I can be able to. Oh, this is the last. Okay, well, there's an application process. That application is provided by the state, and so it does not provide a witness signature in there.
Vice Chairman Wright. Representative Mitchell, you're recognized, please.
Yeah.
Light up, right.
Mr. Chairman, thank you. And I was just going to reiterate what the sponsor said. It's not required now, witness. And if we need an expert on the situation to testify, I think we may have someone who handles that in Davidson County in the audience that could tell us how she does that for one of the largest counties in the state.
Thank you, Representative Mitchell. Representative Dixie, you're recognized.
Thank you, Mr. Chairman. Not sure if the sponsor can answer this. Well, I think you can because you worked in the in the office before. Is this process any different from the veterans? Right now, do veterans have to have, they submit their form for their reduction? Do they have to have it notarized or witnessed?
Representative Harris,
No, they don't have to have that.
any follow-ups?
Thank
Any other questions for the sponsor? Is there objection to the question? Hearing none, we're voting on House Bill 1380 as amended. Madam Clerk, open the voting board. Every member cast their vote. Does any member wish, has every member voted? Does any member wish to, every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 4 ayes, 1 no, and 1 present not voting.
The ayes prevail. House Bill 1380 as amended moves to the next available calendar, state and local government.
Thank you so much, committee, and thank you, Chairman.
The next bill on our calendar, and I want to say a great thank you to the members of this committee. I know it's one of our longest calendars. I appreciate all your help. I really do. The next bill on the calendar is House Bill 436 by Chairman Crawford. We have a motion and a second. Chairman Crawford, you're recognized.
Thank you, Mr. Chairman. May I present from my chair?
Without objection, so ordered.
Thank you, sir. House Bill 436. Who will benefit from us passing this? The law applies to certain disabled veterans in the state of Tennessee. The state will pay or reimburse these disabled veterans for part or all the property tax that they pay on their home each year. The reimbursement applies to $175,000 of the home's full value or full market value. And it is then assessed by 25% of the value of it, then they take the addressed amount is to go to the local property tax rate and where you live. And so it's bringing that back to locals. The new law will state that tax years beginning on July 1st of 2025. That's what the bill does.
Is there questions on the bill? Is there objection to the question? Hearing none, we're voting on House Bill 436, moving to the next available calendar, state and local government. Madam Clerk, open the voting roll. Every member cast their vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
The ayes prevail. House Bill 436 moves to the next available calendar, state and local government. The next bill is House Bill 842 by Chairman Crawford. We have a motion and a second. You're recognized on House Bill 842, Chairman Crawford.
Thank you, Mr. Chairman. Committee, what this bill does is make one simple change.
And you do have an amendment. Is that correct?
I do. It's Amendment 4869.
We have a motion and a second on Amendment 4869. Does it rewrite the bill?
It makes the bill.
It makes the bill. Is there objection to the question? We're voting on Amendment 4869. All in favor say aye. Aye. Opposed say no. The ayes prevail. House Bill 842 is amended. You're recognized on 842 as amended.
Thank you, sir. This makes one simple change. This is how TWRA can use their wetland acquisition funds. The governor has put this into his budget. It's a one-time $30 million grant. And what they're going to use the money to do with it is to spend down the balance for staff and law enforcement positions, and also to take care of some of the backlog of the capital projects across the state.
You've heard the explanation of the sponsor. Is there questions or comments? Is there objection to the question? Hearing none, we were voting on House Bill 842 as amended. Madam Clerk, open the voting roll. Will every member cast their vote? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
The ayes prevail. House Bill 842 as amended moves to next available calendar, state and local government. Next bill on our calendar is House Bill 733 by Chairman Crawford. Is there a motion? We have a motion and a second. We're in proper posture. Chairman Crawford, you're recognized on House Bill 733.
Thank you, Mr. Chairman and committee. I will make this as simple as I possibly can. This basically does one thing, and that's go in there and allow people to bypass the locals from their Board of Zoning Appeals and allows them to basically bypass that and go straight to the State Board of Zoning Appeals.
Is this a comptroller bill?
No, sir.
Okay, at this time, we do have a person that has signed up to speak. So we'll go out of session. If the person will come forward to give their name for the record, we're out of session.
Thank you, Mr. Chairman. Thank you, members of the committee. My name is Will Denami, and I'm here on behalf of the assessors of property. And it's not normal that I'd be testifying against my friend and the chairman, and I certainly wouldn't want to do that, but I'm here because this bill.
On the bill, sir.
Yes, this bill is opposed by assessors of property. I'm here to urge you to vote no. This bill goes basically back in time from what we've been trying to do for the last 8 years, and the General Assembly has voted with starting in 2017, Public Chapter 103, which brought notice to the county boards, Public Chapter 13, which required county board training in 2019, the informal reviews with the assessors of property in 2020, this procedure for interest, 2021, the Assessment Appeals Commission. Yes. Thank you, Mr. Chairman. To make it simple, for the last 8 years, the General Assembly has almost unanimously moved legislation that encouraged property tax appeals at the local level, at the County Board of Equalization, informal reviews prior to the County Board of Equalization, and even went as far as to delete the Assessment Appeals Commission at the State Board of Equalization. And the reason is to try to settle appeals faster at the local level. Once they go to the state board, they tend to go on for years and they rack up interest. This bill will take us backwards. We urge you to vote no, Mr. Chairman. And I'll answer any questions.
Any questions? Representative Butler, while we're out of session, you're recognized.
Thank you, Mr. Chairman. So let me ask you a question. Being somebody that's in the military, we always follow a chain of command. So the local level, I'm assuming, would be your first step to appeal this. Why would we want to bypass the local step to hopefully resolve it on a local issue and not take this to this? I'm just trying to understand this.
Mr. Nam, you're recognized.
Thank you, Mr. Chairman, and thank you for that question. We believe the best public policy is to try to resolve it at the local level, and this bill would bypass that, so that we don't think it's a good idea.
Representative Butler.
Thank you, Mr. Chairman. So why would a taxpayer, if there is some kind of question here, why would they want to bypass the local? I mean, why would they want to go to the state?
Thank you, Mr. Chairman. Thank you for that question. So there's an industry of people who are professionals at filing property tax appeals. And so if you just look at how that is structured, it's to their benefit if they're a professional appeal filer to let it run as long as possible and generate as much interest as possible at the state level. Not the taxpayers, not at the taxpayers' benefit. It's to those professional filers. So the taxpayers as a whole and individually are best served having it resolved as quickly as possible at the local level.
Representative Butler, follow
Thank you,
up.
Mr. Chairman. Just follow up. So if I bring this to the state board, what kind of interest rate are you talking? You're saying that there's interest being accumulated. I mean, what are we talking about? 5%, 10%?
It's prime minus 2 points.
Prime plus, excuse me, one more time.
Thank you, Mr. Chairman. Prime minus 2.
Okay. Thank you, Mr.
Representative
Chairman.
Butler.
Thank you. I'm done.
Is there any other questions? Seeing, hearing none, we'll go back into session. Chairman Crawford, we're back on House Bill 733, sir.
Thank you, Mr. Chairman. And what was conveniently, I think, left out of that was the simple fact that our local cities and counties are kind of abusing this. They may have the right to refuse and accept the payment. And what's happening is they're putting our Tennesseans into a delinquent tax situation. And they keep them in that delinquent tax situation until they can get their appeal heard. And then so it's costing them more because of the interest and those type things. And this would just, if they continue to drag their feet, it gives them the option to go to the state and have it fixed.
Representative Butler, you're recognized on the bill, sir.
Thank you, Mr. Chairman. So if they debate what they're owed, do they not, they don't pay any portion of that tax? They just basically just wait, or do they pay it and then get reimbursed?
Chairman Crawford.
I don't really know the answer to that. I think it's kind of fly by the seat of your britches. I may be totally off on that, but I think sometimes they have had to pay a portion, and that's up to the property assessor. They can accept a portion of it or not accept it. So, you know, at the state level, they would have to pay it. I think they'd have 30 days to pay it.
Representative Butler.
Thank you, Mr. Chairman. So there's really no standardized procedure for this in all 95 counties. Each county kind of does what they want to. Really, they handle it, but it's not handled in a uniform manner. Is that what you're saying? Or do you know?
Chairman Crawford.
I would not say that. I'm sure there's a standard operating procedure that they follow, but I'm saying that it may not get done correctly every time.
Representative Butler.
Thank you, Mr. Chairman.
Any other questions or comments? Is there objection to the question? Hearing none, seeing none, we're voting on House Bill 733. Madam Clerk, open the voting board. Members, cast your vote. Has every member voted? Does any member wish to change their vote? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 733 moves to the next available calendar, state and local government.
All right, item number 33. This is House Bill 0083. Got Chairman Moon is the sponsor. You're recognized on your bill, sir. I do see it has an amendment.
Motion amendment.
Yes, she's.
It does have an amendment.
4802.
4882. 4802, I'm sorry.
Thank you, sir. Would you like us to place it on the bill for discussion?
I would rewrite the bill, Mr. Chairman.
All right. All right. All those in favor of placing amendment number 4802 onto House Bill 83 for discussion, please say aye. Opposed, no. Bill's now amended. You're recognized on your bill, Chairman.
Thank you, Mr. Chairman. Since 2001, all counties have been required to provide ambulance services. Cost at that time could not be reasonably determined according to the fiscal note making the bill. At that time, cities may offer ambulatory services, but are not required to. But counties are by a mandate of the law. This bill asks that a TASER study be conducted that will help the General Assembly identify the number of counties and cities offering ambulance services, which local governments are contracting those services, identify funding gaps per reimbursements, and to provide for a better understanding of how they are covering their losses. This bill has been brought by Murray County and supported by the interest of the Tennessee County Mayors Association, the Tennessee County Service Association, and the Tennessee Ambulance Services Association. Mr. Chairman, I stand ready for any questions.
You've heard the explanation of the sponsor. Are there any questions for the sponsor? Seeing none, we're ready to vote on House Bill 0083. Madam Clerk, will you please open the board for voting? Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board and announce the vote.
Mr. Chairman, you have 7 ayes.
Okay. Chairman Moon, your bill will move on to the next available calendar on state and local government.
Thank you, Mr. Chairman and committee.
Item number 34, House Bill 935 by Chairman Moon. I do see we have an amendment. Do I have a motion?
Motion.
Proper motion. Is there a second? Properly motioned and second. I do see we have an amendment.
It's Amendment Drafting Code 5463, Mr. Chairman.
That's correct. We got a proper motion in second. Would you like us to place it on the bill for discussion?
I would, sir.
Without objection, we'll place Amendment 5463 on to House Bill 935. All in favor, please say aye.
Aye.
Opposed, no. Bill's now amended. You're recognized on your amended bill, Chairman.
This bill as amended creates a new part to allow counties that self-insure for health insurance who operate under the Purchasing Act of 1957 to require a competitive bid process for insurance brokerage service. This would be optional and would be up to the county legislative body to decide. This bill comes at the request of Blount County that previously required a competitive bid for these services, but as we know, that there's no bid professional service process. If this provision is not enacted, it would bar us from competitively bidding. So it's permissive. It only allows counties that self-insure under the 1957 Purchasing Act and allows the legislative body to require competitive bid for insurance brokerage services. I stand ready for any questions.
You've heard the explanation of the sponsor. Are there any questions for the sponsor? Representative Mitchell.
Yeah, thank you, Mr. Chairman. Chairman, sponsor Moon, is it your intent on this? You know, we hear insurance brokerage services. You know, an insurance broker, he can go out and he can get three quotes from 3 different insurance companies. So is it your intent that it's not the person who has the business currently, but it's 3 outside entities not controlled by the one currently who has the business?
Chairman Moon.
The intent of the legislation is to competitively bid to that broker, that advisor, that it would go out and seek the best dental coverage, the best hospitalization, best accident insurance. That's the intent. And we did that until the legislature acted to require, because of professional services, it stopped it. So we're asking that be reauthorized, competitive bidding be reauthorized for only those counties that self-insure.
Okay.
Thank you. Is there any other questions for the sponsor? Seeing none, we're ready to vote. All those in favor of voting for House Bill 0935, please vote yes on the board or no on the board. Madam Clerk, open board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the vote. Close the board and announce the vote.
Mr. Chairman, you have 6 ayes.
Chairman Moon, your bill moves on to the next available calendar for state and local government.
Thank you, Mr. Chairman and members. Now, that takes us back to the heel of the calendar, and I have Chairman Rudd is the next person present. If you'll give me one moment to get organized, sponsor. See, that's item. Chairman Rudd, you're at, it's item 5 on the calendar, House Bill 319. Is there a motion? Is there a motion on 319? It's item 12, excuse me. I'm sorry, excuse me. It's House Bill 319. Everybody in good order? Is there a motion on House Bill 319? There's a motion on second on House Bill 319. You're recognized on the bill. Do you have an amendment?
Yes, Mr. Chairman, drafting code 5782.
Is there a motion on the amendment?
That makes the bill.
Is there a motion on the amendment? Motion. I have a motion. Is there a second on Amendment 5782? Is there a second? Second. There's a motion and a second on Amendment 5782. It rewrites the bill. So, is there objection to the question? Hearing none, we're voting on Amendment 5782. All in favor say aye. Aye. Opposed say no. The ayes prevail. House Bill 319 is amended. You're recognized on the amended bill, sponsor.
Thank you, Mr. Chairman. What this bill does is it addresses a very, very important situation that has popped up. It's one of the most important bills that we'll be voting on this session that's kind of been under the radar. The intent of the legislation is to reaffirm current state law and correct a Memphis judge who misinterpreted the original intent of state law that has been in place since 1973. The bill has no fiscal impact on locals. The previous legislation did not either. However, Fiscal Review gave it a $78 million, so we put this bill on, and that was because of false information provided by the DPA. Nearly every county in Tennessee assesses property at the 52-year-old standards. The DPA is demanding to change and reflect incorrect judicial decisions that reinterpret existing state law that's been in place for over 50 years. The current law states that all residential homes are taxed at a residential rate of 25 cents regardless of owner-occupied or rental. Apartment complexes are taxed at 40 cents. The legislation clearly defines residential and commercial properties. Currently, residential definitions are vague enough that the courts and the DPA attempt to institute policies that would institute a statewide $78 million property tax hike across Tennessee in every county on the homeowners that rent property. This would be passed and onto the renters, resulting in a devastating impact of affordable housing. The last thing we need is government bureaucrats forcing Tennessee's poorest to raise revenue. The burden of revenue generation should not be placed on the backs of assessors. It should rest on the powers of the governing body of locals. Timeshares and short-term rentals are covered in a separate part of the code. Those opposed to this legislation have been trying to confuse people and say this affects timeshares. It does not. Like Airbnbs, they are hospitality and lodging, not residences. A lobbyist who's opposing this legislation and with the goal of generating more revenue for locals has been spreading false information and scare tactics about the legislation. Apartments are also not covered. The legislation states in Section 1 under residential property that it means it has a unique property identifier that allows it to be owned and contain no more than one rental unit. Also, a townhome of the property where the owner owns the interior, exterior, and a portion of the land. The bill is a cleanup to correct a judge's misinterpretation. If the bill does not pass, our counties are facing a property tax hike of $78 million or more. The legislation is a proactive solution to support housing affordability, protect property rights, and ensure economic stability for our constituents. With that, Mr. Chairman, I'm open for questions. And I believe there's some testimony.
Thank you, sponsor. At this time, we have people who've requested to speak on this item, so we will go out of session. Our first person that would like to speak is Bruce McNeilage. If he's available, please, if he'll come forward. And if you'll have a seat at the table, sir, and give your name and who you're with. You're to center, I believe she.
My name is Bruce McNeilage. I'm the president and co-founder of Kinlock Partners. We are a local residential single-family rental operation.
Thank you, sir, and you're recognized for 3 minutes.
This is going to be 13 words, and some of them are the same. Affordable housing, affordable housing, affordable housing, the American dream, and the death of the American dream. And I'm in the American dream business. I'm a member of the Middle Tennessee Home Builders Association, the Williamson County Realtors Association, and I'm the chairman of the Tennessee chapter of the National Home Rental Association. I've been a successful affordable condo developer and owner of multifamily residential for 20 years since moving here. And this is not a good bill. This is going to pass a tax directly on to the person that rents the house. I'm going to pass it on. If this tax goes, and I've got 3 of my addresses here on what it would do, about $1,200 a month, a year, I'm going to charge $100 more to rent that house. And I have brand new rental houses. My houses in Fairview are worth $515,000. I charge $2,400 a month to live in Williamson County. Granite countertops, stainless steel appliances, covered front porch, covered back porch. We give people the best deal in town on a brand new house. And we can't afford, with the cost of insurance and taxes, to do any better than that. So we're going to raise the rent on 68 houses. That's going to be over $100,000 if this doesn't pass. I have peers in this business, because I'm head of the chapter, that are going to raise taxes millions of dollars. And I'm not Wall Street, I'm Main Street. I live in Brentwood, I've lived in Spring Hill and Thompson Station. This is not a money grab. This is not saving money for operators like us. We own individually deeded, individual tax parcel houses. Every one of our houses is available to buy at any time during our lease. We'll rip up the lease and sell you the American dream. In the last 2 or 3 years, we've sold 1 house. People are renting because of high interest rates and because they can't afford to buy homes. Well, if this doesn't pass, now you're not going to be able to afford to rent a home, because the big landlord, me and others, are going to raise your rent. It's just a pass through for us. Insurance is killing us. Borrowing money to buy and build houses for these people in Tennessee is getting tougher. And this is, in my opinion, my humble opinion, going to hurt your constituents and my constituents. My constituents are the people that rent houses from me. So in my opinion, if you vote for this, you're voting for affordable, attainable housing.
Thank you for your testimony very much. Next person we have on the list is Jimmy Dooley.
Could I ask a question?
With that, Vice Chairman Wright, you're recognized.
Thank you, Mr. Chairman. I had to get, I say this tongue in cheek, legal advice as we were sitting here listening to the testimony. So I need to be clear about what you're saying from when you started to when you ended. You do favor this legislation?
You're recognized, sir.
Yes, sir. Yes.
Okay. Thank you. Representative Dixie.
You stated that you would have to pass, if they raise the taxes, you would have to pass it on to the.
It would be a pass through. I wouldn't make $1 off it. It wouldn't cost me $1.
So
Representative Dixie, you're recognized.
My question is, currently, do you not pass it through?
McNally, you're recognized for an answer.
That's a good question. First of all, I want to apologize for not thanking you,
that's
Mr.
fine.
Chairman,
That's
and the
fine.
people to hear me speak today. We make a profit based on the debt that we borrow, or what we borrow money at. And then we have expenses. Our biggest expense is property taxes. Our second biggest expense is insurance. And then we have maintenance and repairs. That's basically it. So as insurance is going up, as taxes are going up, yes, those are a pass through, but we can't raise rent right now because of the economy that we're in. We raised rent this last year, $25 a house. And this would cost an average of our house is about $1,200.
Representative Dixie. Thank you for your testimony.
Thank you, sir. Thanks, Mr. Chairman.
Next person we have on the list is Jimmy Dooley. If you'll come forward, Mr. Dooley. If you, for the record, give your name and who you're with.
My name is Jim Dooley, and I'm a private citizen. However, I was privileged to serve 40 years as the Murray County Assessor of Property, and also privileged to serve on the State Assessment Appeals Commission for many years. I am not going to rehash everything that the sponsor has mentioned here, but I see families who own more than one home and possibly have say a mother-in-law or a child or somebody else suddenly caught up in this. In the 40 years that I was an assessor, a single family property was never assessed commercially. But I encourage you to pass this on to the State and Local Government Committee, and I think that is in the best interest of our citizens. Thank you.
Any questions? Thank you for your testimony today. We have one other person on the list, and that is Mr. David Connors. If you'll come forward, sir, and give your name and who you represent.
Thank you, Mr. Chairman. David Connor with the Tennessee.
You're recognized for 3 minutes, sir.
With the Tennessee County Services Association. I'll be brief about this. Our association represents 95 county governments in Tennessee, and we have concerns about specifically a portion of the amendment that has been added to this bill. I believe the fiscal note on the bill is accurate that was provided by our Comptroller's Office Division of Property Assessments. They have identified over 40,000 residential properties in Tennessee that are currently being assessed at the commercial rate because they are held. Some cases by real estate investment trusts, some cases by other owners, they're being held as income producing property. They may be lived in by people, whether it's on a short-term basis or a long-term basis through rental, but they're income producing property and they're assessed at the commercial rate. There was a Supreme Court case that certified that that should be the case and they should continue to do so. This bill would change that, but what I want to specifically highlight in the amendment is Section 3. The amendment itself would appear to eliminate the fiscal impact to local government, but the way it's doing that is by saying if this bill passes, every city and county across the state is supposed to look at and evaluate their current tax rate and determine a new tax rate that will generate the same amount of revenue as what they had been getting previously. So essentially, the bill is creating a tax reduction for people who currently have these properties that are assessed commercially. I can't speak to the specifics of how many are really out there, but the Comptroller's Office has identified a large number and that it would be a huge decrease in tax revenue. And then the new amendment in Section 3 would require every local jurisdiction, cities and counties, to reset their property tax rates to make up for that lost revenue. So essentially, you are mandating in that Section 3 a rate increase all across the state, whether you want to be doing that or not. There could be debate about exactly how much reduction in revenue would occur, but you're going to require every jurisdiction to raise their rates to make up for an anticipated loss of revenue through other provisions of this amendment.
Representative Mitchell, you're recognized, sir.
Yeah, thank you, Mr. Chairman. So in essence, what you're telling me is to keep the property taxes low on these big investors and these REITs, we're going to raise the property taxes of everybody in the community to make up for what their property tax is going to go up.
Mr. Connors, you're recognized.
That is the way I interpret the amendment. Yes, sir.
And
Representative Mitchell,
Yeah.
you're recognized.
thank you. And in essence, this bill is a mandate to raise property taxes.
Mr. Connors.
Thank you, Mr. Chairman. That is my understanding of the bill is that it's going to create a reduction and then mandate that every city and county adjust their rates to make up for the revenue.
Representative Mitchell, follow up.
It does say shall.
Any other questions before we go back into session? Thank the people who came forward today to testify on this bill. We greatly appreciate it. We'll go back into session. Chairman Rudd, you're recognized on House Bill 319 as amended, sir.
Well, thank you. It's that was incorrect. They certainly can if they want. I intend to fight the fiscal note on 4413 because that fiscal note on the original was purely based on what the information that the DPA, the Department of Property Assessments, provided to them, with the assumption that all counties were going to abide by their ruling. Right now, the vast majority of counties are doing it the way they've been doing it, the way this bill does it since 1973. There are very few counties that have adopted to what the comptroller and the DPA are wanting them to adopt to, which is a mandatory property tax hike. Right now, I've had assessors call me from around the state saying they like the bill, but why are we passing it? This is what we already do. I've had numerous ones in Middle Tennessee from Dixon, and I've had commissioners in Williamson County and other counties call me. We're already doing it this way. I said, they didn't even know the comptroller was going to force this on them like he's been doing it on a few counties. So most of the counties don't even know they're going to be expected to do it. So the fact that the comptroller and the DPA have told the fiscal review that the 78 million is because if every county taxed like they're wanting them to, which most have not even been informed to do that yet, that would generate 78 million in additional revenue. Therefore, that is false. They haven't even implemented it yet. They're going back to last year, which the bill states, that was not implemented. This is a recent, in the last 8 months, is what the DPA has been requiring a handful of counties to do. And some counties have refused to do it. And they're threatening to oust them or punish them or decertify them if they don't do it. But most counties are not even aware that they're expected to do anything differently than what's in my bill.
Okay, any other questions? Representative Butler, you're recognized on the bill, sir.
Thank you, Mr. Chairman. So I'm a little confused here. The gentleman that testified earlier talked about single-family homes. But this amendment talks about residential property, and I quote, also includes real property that is constructing as a dwelling unit in a group of 2 or more attached dwelling units. That is not a single-family home. So I own a second home that my parents live in. So what I'm curious to know is am I going to be charged a higher rate? That is not an income producing property because I'm not getting any rent on it. They're living there for free. So I'm a little confused on, are we going to charge at a higher rate on single family homes that are being rented? Or are we going to keep them at a lower rate at the 25% rate instead of the 40% rate?
Chairman Rudd.
Well, my bill fixes that. The way we do it now, we do not. All single-family residences under the current way we've been doing it for 50 years and the way we did it under the bill would not be taxed, whether they're rental or you live in them. Under the DPA's ruling and the judge's interpretation, you would have to start paying commercial on the others that you're not living in.
Representative Butler.
Thank you, Mr.
Now,
Chairman.
Also, it was mentioned about the what you'd mentioned, that definition of property, that was concerning condos. And right now, condos are taxed except for the one you live in. If you live in a duplex, the one you live in is residential, single family tax rate. If you rent the other side out, it's commercial. If you own the duplex and rent both sides out, they're both commercial. If you own a townhome, it's different. Townhomes are treated currently as like a single family home because you own the property under it. And it's considered a separate unit. It's not considered a duplex. So this would, again, all this does is reaffirm what we're already doing. And as far as to get the fiscal note off, that is incorrect. That is still, you shall do it, but that is still up to the locals to set the rate. And I'm hoping that we would have moved this off Section 3 altogether if I can appear before fiscal review and get them to remove that. If not, we'll go with this.
Representative Butler.
Thank you, Mr. Chairman. So where do we come up? I mean, how do we come up with $72 million or 78 million? I've heard both numbers thrown around. If this is statewide applicable and we're already collecting in a handful of counties and not the rest of them, then where did the $72 million from? If we're not doing this in 90 counties, then that the other 5 counties attribute or come up with the $72 million. I'm just not clear on that.
Chairman Rudd.
Thank you, Chairman. That is what was provided to fiscal review by the DPA. And if they're coming up with 40,000 single family homes that are rented, Rutherford County, I think, has 19,000 alone. They're way under. It's we have huge numbers of homes. I live in Rutherford County and Murfreesboro. In my subdivision alone, I own my home. There's about 1,200 homes in my subdivision, and 600 of them are rentals. And some are owned by mom and pops locally that were born there, and some are owned by corporations. And I wish there weren't any, but those are still people who can't afford to buy. If we price them out of the market and almost go up 30 to 40% on their lease, they're not going to be able to afford that. What are we going to do? The whole reason why for the last 50 years that we've kept single family homes taxed as if you live in them is because if the tax went up, people couldn't afford to live there. These people, they're due to interest rates or credit scores, or young people started out or senior citizens can't afford to buy a new home today, so they have to rent. They would be forced to move into apartment complex or forced to leave the state and live in a more affordable area. And that's what this bill does. Because right now the DPA and the comptroller and the judge's decision is forcing, if we abide by this, if we make this statewide what they're doing to a handful of counties, it is going to be a mandatory property tax hike. And it will probably generate up to 200 million, not just 78 million.
Representative Butler.
Thank you, Mr. Chair. How many counties right now are charging at the higher rate on single family homes?
Go ahead, Mr. Chairman Rudd. Excuse me.
I have asked that when I've met with the comptroller, and they've never provided that, and I don't think they know. No one's provided that. I just know that people have been calling me in. We're unaware that other counties were being required to do anything other than what's in this bill.
Thank you, Mr. Chairman. My concern is you listen to folks come give testimony. You have folks come in your office and talk about this, and you're getting 2 completely different stories. It's really hard to disseminate where the truth is. Are we going to cause a tax increase and increase taxes across the board, or are we going to protect a tax increase on homes that will drive the cost up? Because I understand the gentleman that testified, if his property tax goes up, he's got to go up on his rent. That's just business. It's economics. I understand that. However, I don't want to spread the tax burden on a greater number of folks if we're offsetting this. I mean, it would be good to know how many counties are participating in this, and that would help us ascertain where the 72 or the $78 million came from. Thank you, Mr. Chairman.
Chairman Rudd.
Well, there's one thing for sure, Representative Butler, one thing without a doubt. At the rate we're going, well, we know how it's been since 1973 up to last year. The single family homes were not taxed commercially. Just in the last few months, the DPA is in a handful of counties that I'm aware of, and Rutherford's one of them. I think some are adapted to it. While Wilson said no, Williamson said no, Dixon said no, and some of them don't know about it. That's called me. It's obviously that a huge number of counties are not even aware that they're going to be required at the reassessment at the end of the year to even tax these rental houses. Now, of course, a lot of rural communities don't have a lot of rental, but some do. John Mark Wendell, who was former state rep here, and Lowell Russell, who owns them now, they own hundreds, just them two. And those are in rural areas. And poor people in these small homes are going to be devastated by this. And this would be statewide. These taxes, we know, as of the beginning of last year, were not on any single family homes in this state. And I believe Knox is adapted to it, but even in Knox, on their own county website now, the assessor is still taxing condos at a single family rate. If they've adapted to it, it's on their website right now. So it's going to be hard to implement, but they're trying to implement it now. And if it is implemented, what they're trying to do, it will most certainly drive up property taxes, and that will be passed on to the renters.
Representative Butler. Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. I think none of us are on the same page right now. So I would like to move this to the first calendar of next year so that we can kind of get more information, if you're willing to do that.
We have a motion to move this as first calendar of second session. We have a second.
If we do that, it's going
Is
to
there objection
guarantee
to
a
the
tax hike.
question? Is there objection to the question?
Can he respond, please?
Chairman Rudd, you're recognized on the motion
Chairman,
to
if we do
move
that,
this to the next calendar.
if we do that, their tax that the DPA and the comptroller is trying to pass on and this judge out of Memphis, it's going to go through because the assessment will be done by the end of the year. So it would be irrelevant. They'd have to back out a whole year and refund people money if we change the law. So they're in an assessment year now and they're changing the rules now in the game. And if they assess at a higher rate and force all the counties to do this, it'll be too late.
I
Madam Chair
withdraw.
Lady,
I withdraw.
Madam Chair Lady, the motion belongs to the body, but without objection, hearing no objection, Madam Chair Lady's motion's withdrawn. Representative Mitchell, you're recognized on the bill, sir.
Yeah, thank you, Mr. Chair. And I keep hearing, as my colleague from Dixon County said, we're hearing multiple stories here. I'm hearing Supreme Court, then I'm hearing one judge, then I'm hearing some counties are doing, some counties aren't. If there's a court order mandating this, I'm wondering why some of these counties aren't doing it because they're violating the law. And if it's only one judge, we do need to sit back and wait for, as Justice Roberts said yesterday, proper appellate review until it gets through the system and not get in the way. So I'm just trying to figure out, which way. But, I know one thing. We pass this, it says we shall raise property taxes. And I'm, I used to be on the Metro Council, and that's what we did there. We raised or lowered property taxes. But last time I checked, General Assembly, we don't do that. I think we passed a constitutional amendment earlier for no property tax in the state. Now we got a bill, somebody's raising it. So with that being said, the kind lady from Dixon County stole my thunder with my motion, but I'm going to make that same motion. I think we need to wait and step back, and I move this to the first calendar of the second session next year.
The motion's out of order. We've already had the motion before us and taken action, so it's not proper motion.
Well, I'm sorry then, Mr. Chairman, we move this to summer study then.
We have a motion to move summer study. Is there a second? We have a motion and a second to move to summer study. That's final action. So we'll be on the board. Madam Clerk, open the voting board. The motion is to move House Bill 319 as amended to summer study. Members, cast your vote on the motion to move this to summer study. Say again? Is this final action? It is a final action, yes, sir. We're in the process of voting, so there's no discussion and no debate is proper at this time. The pending motion is to move House Bill 319 to summer study. Members, the voting board is open. Members, cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 4 ayes, 1 no, 2 present not voting.
The motion to send 319 as amended to summer study prevails. Next bill on the calendar is House Bill 92 by Representative Hardaway. Do we have a motion?
Motion.
Do we have a motion? Do we have a second? Do we have a second? Representative Hardaway, you narrowly escaped. You're recognized on House Bill
No,
92.
sir. One of your members barely escaped. Mr. Chairman, first, I want to appreciate the grace that the subcommittee has provided to me, running back and forth with my own committee. But there's some unreadiness among the members. So without getting into the details of the bill, which is, we did have a room full of folks that you may have seen in red who support the bill and were here for comments, even though they didn't get registered. So I'm going to ask that we take this off notice.
Sponsor asks this be taken off notice without objection. Hearing no objection, House Bill 92 is off notice. The next bill is House Bill 993 by Representative Hardaway. We have a motion. Do we have a second? Wait a minute. You made a motion. You can't make a second. Excuse me. All right. You have a motion and a second on House Bill 993. You're recognized.
Thank you, Mr. Chairman. I actually need a couple of my other friends to start doing the motions.
On the bill, sir.
Mr. Chairman, again, thank you for the grace that the committee has extended. This bill is, we have an amendment. We weren't able to get it on in time. And it's a local bill, locally permissive, that would require 2/3 of the local legislative body. So we'll be ready to go next year, but I'm going to ask that the committee would take it off notice.
You've heard the request of the sponsors. Is there objection? Hearing no objection, House Bill 993 is off notice.
And thank you. And the reason I waited is, of course, y'all waited on me. Okay, and I want to show the committee due respect. So thank you.
Thank you, Representative Hardaway. House Bill 832 has been requested. The sponsors requested that be taken off notice. House Bill 832 and 42, but we'll take them one at a time. House Bill 832. House Bill 832. That was item number 2 on the calendar by Marsh. Is there objection? Hearing no objection, House Bill 832 is off notice. Now, the next bill we have is House Bill 742, but it's item 27 on today's calendar. It's getting late, folks. Is the sponsor available? I understand now we've gotten an email asking that House Bill 742 be taken off notice. Is there objection? Hearing no objection, House Bill 742 is off notice. That should complete our calendar for today. Now we'll take up the special calendar. And we have one item on the special calendar, and that's House Bill 426 by Representative Love. Chairman Crawford, I believe you've got action on that. It's on the special calendar. It's House Bill 426. I thought you gave it to him. I believe that's correct, item number 23, but it's now we're on these, we've completed the final calendar. We're now taking up the special calendar.
Chairman.
Chairman Crawford, you're recognized.
Thank you, Mr. Chairman. I would move that we send this to the clerk's desk. House Bill 426.
Proper motion. Is there a second? There's motion and second to send House Bill 426 back to the clerk's desk. Is there objection to the question? Hearing none, Madam Clerk, open the voting. Members, please vote. The motion is to send House Bill 426 back to the clerk's desk. Every member vote? Or members cast your vote? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes.
The ayes prevail. House Bill 426 is returned to the clerk's desk. Now that completes the final calendar and the special calendar. Does any members have any announcements? Seeing none, Vice Chairman Wright, you're recognized.
Thank you, Mr. Chairman. I move to adjourn, subject to the call of the chairman.
We have a motion. Is there there's a motion and a second. Madam Clerk, open the voting rolls. The motion is to adjourn, subject to the call of the chair. Members, please cast your vote. Has every member voted? Does any member not wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes.
The ayes prevail. Cities and County Subcommittee is closed, subject to the call of the chair. No, you guys